We are live. I want to welcome and thank our audience for attending. Today we are presenting on the Subsequent Injuries Benefit Trust Fund. I have a great panel of guests here and I will have them self-introduce. First off, we have Brett Mad Dog Borah Esquire. Brett, can you introduce yourself real quick?
I'm Brett Borah. I'm an applicant's attorney in Cupertino, Northern California.
Okay. Next, we have attorney Dennis Thomas.
My name is Dennis Thomas. I'm an applicant attorney at the other end of the state down in Huntington Beach, California.
Great. Also, we have Dr. Richard Skala.
Good afternoon. My name is Dr. Rick Skala. I'm a doctor of chiropractic. I've been doing QME since 1992. I've been doing SIF cases for several years. And I want to thank you for letting me participate today.
Very good. And last but not least, Dr. Michael Newman.
I'm a chiropractor in San Jose, very close to Mr. Borah's office, where San Jose meets Cupertino. I've been at QME as long as there has been the QME process. Prior to that, I was a state-appointed independent medical evaluator as well. I've been doing SIBTF cases for about 20 years now and have substantial experience in the arena. Great,
great. And again, thank you all for participating. Our goal here is to impart some education on our audience. The Subsequent Injuries Benefit Trust Fund has been exponentially utilized in the last few years. It's caused some good things and some bad things. We're going to kind of wade through a little bit of the background. Then we'll talk about threshold issues. And then finally, we'll just wrap it up with some best tips. So first, I want to kick this off just by getting us a background of SIBTF. And Brett, could you help us understand the origination and what has and the evolution of the Subsequent Injury Benefit Trust Fund?
Sure, happy to. So somebody famous once said, it's best to begin at the beginning. So let's do that. The Subsequent Injuries Fund, as it was originally known, and maybe 5 years ago, the name was changed to the Subsequent Injuries Benefits Trust Fund. SIF, SIBTF, it's all interchangeable. Different people use different nomenclature, but it's all the same. So this fund was begun in the 1950s, and it was started because guys were coming home from World War II in Korea, and a lot of employers said they didn't want to hire these returning veterans because they were afraid that if they got injured on the job, they would get stuck with liability for some pre-existing disabilities incurred during the war. So the state of California, in one of the few instances, did the right thing and stepped up, and most other states did too. There's some form of SIF in almost every state. They stepped up and they said, listen, we, as a matter of public policy, we want you to hire our veterans and get them back to work. So if they have significant workers' comp injuries on your job, and significant is important, we'll come back to that in a minute, and they have pre-existing disabilities, meaning military injuries, but they didn't say that. They just said pre-existing disabilities. They said, we will cover those pre-existing disabilities. Now, that started the SIF, which was kind of a sleepy little fund for many years until, I think it was 899, where they changed the apportionment laws. And all of a sudden, SIF became very important. We developed COLAs, and that dramatically increased the importance of the SIBTF. The purpose of this program today is to try to give people who don't do SIBTF cases, have heard of it, don't really know where it's going, to give them some guidance. And the example that I'm going to give you, my wife and I were going to go out to dinner the other night. So we got in the car and I got out of the garage onto the street, turned left, went up, turned left again, got on the freeway heading north. And after a few minutes, my wife said, well, wouldn't you like to know where we're going to dinner? And I said, well, yeah, I guess I'm going to have a little trouble getting there if I don't know where I'm trying to go. And that's the point of this webinar, is to try to help you see where you're trying to get to so that you can get there. The relevant code sections on this, and these are, I think, the only codes we're going to give you today, are Labor Code 4751 and 4753. Everyone should read those. These are critical. They're short. They're only one paragraph each, but this is where it all comes from. That's the beginning. What you have to remember in doing SIBTF cases is that it flips everything that we know as applicants' attorneys on its head. When I practice my workers' comp claims, I hate apportionment. That is the enemy. Avoid it at all costs. Once we start looking at SIBTF cases, however, apportionment is the greatest gift we ever got. Let me just give you one example, and I'll come back to this case again later to illustrate some other features. I had a case where Lois injured her bilateral knees, and pretty bad, and she was an older woman. We took the case to trial, and the judge gave me 100% disability. Hallelujah, the holy grail, I've made it. And then he went on to say, yeah, but 90% of that was pre-existing. So I wound up really with a 10% case. But what he did was open the door for me to an SIBTF claim. We eventually prosecuted it. We took it back to trial, and because that judge owned the case and was still around, it went back to the same trial judge. And having said 90%, having said 100% disability, 90% pre-existing, he really was stuck with that. I wound up with a 100% award, now less the 10%, which she'd already been paid for. And more than a decade later, my lady is still receiving benefits on that old claim. So I think that's where I would go with this. I think you need to take a look at your workers' comp claims, figure out where you want to go, and then you can figure out how to get there. Dan?
Thank you. Thank you, Mr. Borah. That was a great introduction to what is SIF. Thank you very much. Next piece, John, do we have any questions from the audience? No? Okay. Just want to encourage the audience, if you do have a question, we have specific pauses. They're built in so that we can answer those questions. But we want to move on next to understanding the thresholds. And I'd like to start with Mr. Thomas. Mr. Thomas, you have a preparation for what we're talking about when it comes to thresholds.
Yes, and by threshold, we're looking at how do you know if you have a possible SIF case? Because the labor code, if you read 4751, it may not be the most concise and well-worded statute, and it never ceases to amaze me that when I speak to attorneys, not only on the applicant side, but also attorneys on the defense side, because as an applicant attorney, if you have the requisite steps to make it an SIF case, that might make your relationship with the defense attorney in the case in chief a cooperative one, especially when discussing apportionment like Brett was. So the part that I've been given, which thankfully is probably the easiest, is the two numeric standards that you will often hear. You have to have a 35 standard and a 70% disability. And that statement, although true, is much like saying when you go to your QME depots and the QME, who may not be friendly, says, yes, Dennis, I know apportionment is the causation. Well, that's partly true, but it's apportionment of permanent disability to causation of permanent disability. It's not apportionment to causation and leave it there. So what is the 35% standard? Well, that is the industrial injury. And throughout today, you'll probably hear statements called the subsequent industrial injury. And that is a little bit confusing because some people think, oh my God, the first injury has to be industrial. And we'll get into that later. But the industrial injury must be a 35% whole person impairment in today's language before adjusting for occupation and age, and as we will later discuss, apportionment. So that means that you get to use the modifier, the DFEC or the FEC, which since 2013 has been 1.4. And a lot of people get confused about this. And I've heard people say, Dennis, I'd like to make an SIF, but my my subsequent industrial injury is only 31. And they haven't used the 1.4 modifier or the between 05 and 12, there was the 8 categories. So if you are only looking at the 35% whole person impairment to meet a beginning analysis, you can have as low as 25% whole person impairment. If you multiply that by 1.4, should be 35.
Dennis, let me interrupt you here. Dennis doesn't know I'm going to do this, and we haven't. This is the unrehearsed, unpracticed portion, and I'm going to surprise you. What I'd like is for everybody now to write down a rating formula. So grab your paper, grab your pen, and write this down. And the formula is as follows: 17.05.04.00 -25% bracket 1.4 end bracket 35 -112 -C -27 -22. I will tell you, this is a 21-year-old male clerk with a right knee range of motion injury that I ran this morning. So, Dennis, what you're saying, let me just, I know I'm interrupting, I apologize. But so in this formula, my guy's only got a 22% disability PD. Based on that number, does he qualify?
If we can get a pre-existing, if there is a pre-existing medical condition that will meet the second part of the formula, absolutely.
I'm looking at the 22% PD, the last number. Based on that, does my guy qualify?
Yes, please send me that case.
Based on a 22% PD?
Absolutely.
Okay, I disagree. But I'm only looking at the one number. I'm not looking at the whole formula.
Well, I fail to see how you can look at one number without looking at the whole formula.
For illustration purposes. So this is where the unrehearsed portion comes in.
Yeah.
I would tell you that 22 is less than 35. That number doesn't help you, but that's not the number you want to look at according to what Dennis just told you. Well, let's look at the 27. Based on the 27, no, it's less than 25. And based on what Dennis told you, or less than 35, 27 doesn't get you there. But again, those are after adjustment for age and occupation. It was a 25 standard. Dennis, based on 25 standard, does that get you there? No.
Not by itself.
So what number should we be looking at in this formula?
It's the number after the bracket 1.4 close bracket. That is the WPI that will meet the first level analysis for an SIF case.
Okay.
And that number can be divided amongst 3 body parts. Correct, Brett? So if you had a left knee that was a 6 that goes to 10, and a right knee that's a 6 that goes to 10, and then you had a cervical DRE2 that was a 5 that goes to an 8, you're above, if my math is any good, I think I'm a little short. But the 35 after the 1.4 modifier is for all the injuries from the subsequent industrial injury. It does not have to be one body part or one rating. It is all the parts of the body injured in the industrial injury. Correct? Okay.
Correct.
The second step is there has to be a pre-existing rateable disability, at least for today's purposes, because this is more of an introduction class. There has to be a pre-existing disability. And if you read some of the case law, some of the decisions from the DCA or from the Reconsideration Appeals Board unit will say, we'll put the pre-existing disability first. Some of them want to know if you meet the 35 standard. So the next part, the question that I posed to Brett at the beginning before I knew where he was going, is there has to be a pre-existing disability. And if this gentleman had been a veteran serving in Iraq or Afghanistan and had lost 3 fingers due to an IEA or something, that is obviously a rateable disability. And if that occurred before his industrial disability, we have a pre-existing disability. We have a rating that shows we meet the 35 standard before occupation and age. And all of a sudden, I am 2/3 into my SIF case, with the final requirement being that the overall disability between the pre-existing and the subsequent industrial injury must be a 70 or higher. And so if you look at your caseload and see cases where you have the 25 whole person impairment from 1 body part or 5, and you have the 1.4 multiplier, because remember, in 05 to 012, we have different numbers in there, and so that can play a havoc. But after 113, we have a 35 after the 1.4 multiplier, before occupation, before age adjustments, and before apportionment, because Brett could have thrown me a third curveball by saying the doctor said the knee was 50% from playing college football and 50% from his industrial injury. We'd be down to an 11 as Brett's 100% case. And most attorneys would walk away saying, I don't have an SIF case. And with those 3 amputated fingers, I'd like to take a look at that. The next hurdle might be making the 70%. So 3 elements for your initial analysis. Is there a pre-existing rateable disability? Does my industrial injury meet 35 after the 1.4 multiplier? And then, do I think I can get the injured worker to 70% or higher based on those 2, the pre-existing and the industrial injury? Dan?
Great. Thank you. Mr. Thomas. I want to bring in Dr. Newman, and we had a question about the 5% opposite and corresponding. So Dr. Newman, can you help us understand that a little bit better?
Yeah, a couple more pieces to the story. You've discussed the magic numbers we need. That's 35%, and that's what you have to have before the modifications from the subsequent injury. You often don't have that. So you can get it, and you can get there another way. The other way is to have the subsequent injury rate at 5% or greater and affect an extremity. That means that any case you have where it would be a DRE3, where there's going to be a radiculopathy, that affects an extremity. When you have that, you have to have something that exists on the opposite and corresponding body part, which means it has to be arm in arm and eye in eye, or ear in ear, leg in leg, but it can't be ear and arm. It has to be opposite and corresponding. If you have a pre-existing problem in the opposite and corresponding, that often gets you in the door to go from the case, and then you develop the case from there. Now, I'm going to add a couple pieces I have from my experience, and that is that a lot of the times we're dealing with problems that the applicant doesn't clearly disclose. So what I do when I do my SIF evals is I take an inventory of everywhere that person ever remembered going. I start off with an email to the applicant attorney stating, make sure you get these records, because so much of how we build our storyline is based on establishing pre-injury labor disablement. And it's a really important part. You can't just say that they have something. You need to reference records that show that there's a prior problem. X-rays are really good because they can show arthritis in a body part. And when you have arthritis, that would go with loss of range of motion, which is a rateable impairment. So this is a matter of very carefully documenting all the pieces you need. So when the opposition, the SIBTF attorneys, attempt to attack you, they go after the various levels where you might fail to meet the thresholds. You're well documented to do it. It includes internal medicine, which is a really big part of these cases. It includes psychiatric and cognition, which is a really big part of these cases. And we build the entire storyline that comes to the end of this report where it's very clearly laid out. Your last 4 pages of the report should give you virtually everything you need that says, yes, you qualify for SIBTF benefits, and you need to explain why and how you know what you know. So that's a big part of what we deal with.
Doctor, let me ask you a question. You talk about affecting extremities. How about bilateral vision or bilateral hearing?
They work in this particular case because that's an opposite and corresponding. You get people who have hearing loss from something like police officers with gunfire, and you have established also that they had this in the past from whatever experience. You then have opposite and corresponding. Same thing with visual loss. I see people who are welders who have really serious eye problems. I, in the role of chiropractor, don't evaluate for that stuff, but I send out for internal medicine or a visual specialist who can give me what I need. And we establish pre-existing problems in the eyes as well. So I've gotten in on eyes, I've gotten in on hearing simply by establishing that medical history and the medical records support that these problems were pre-existing problems.
Well, when you talk about opposite and corresponding extremities, what about a right rotator cuff and a left carpal tunnel or finger amputation?
Well,
is that going to work?
It does, because it says extremity. It doesn't say shoulder to shoulder. It just says the word extremity. So it has to affect an extremity. So anywhere from shoulder down to fingertips is the extremity. And it's a matter of doing the work to document that you have a problem in the opposite extremity. Most people, as old as yourself and me, who is pretty close, are going to have some range of motion loss in the shoulders and or elbows. And it's going to be there for a while, because by the time you get to 50, things aren't working as good as they used to work. So it's not that hard to find. It's a matter of just digging, looking at the records and seeing what goes on and what kind of information the applicant related to their physicians in the past, which is often a problem when we deal with people from foreign countries, because I have yet never seen medical records from South America or Iran or any other countries except this country. Simply can't get the records. So you're going to have to make a persuasive argument that there's pre-existing problems, even in countries where you can't get medical records from.
Well, let me stay on this theme for a minute. I've got a client with a lumbar spine injury with radiculopathy down the right leg. No injury to the right leg, but radiculopathy. He's also got a left knee high school football injury. Does that work?
It works as long as there's impairment in the opposite side. You have a case where you're going to rate the low back at least DRE 310%. That takes in the extremity. Anything in the opposite side will work. Part of what I shoot for when I do this is I always want weight-bearing knee x-rays to include sunrise views. I don't know if the crowd knows what sunrise views are, but it's looking down in between the patellofemoral joint, because oftentimes in older people, that space is reduced at least 1 millimeter less than it should be. That opens the door and lets you in. So direct trauma to a patellofemoral opens the door. Loss of joint space interval opens the door. So I look at that knee on all 3 compartments and see if I can bring the knee in for loss of cartilage interval space, which is x-rays on every SIF case, always on the knees.
All right, so the key there is you don't need an injury to both legs or both extremities. You need it to affect both extremities.
True.
Okay, thank you.
We have a couple of questions from the audience I want to get to. Let's see, we have one that's talking about regarding opposite and corresponding, are you limited to the enumerated body parts in the statute?
Take a look at the statute. I don't have it in front, well, I do have it in front of me. I don't think it enumerates specific body parts.
No, well, it does say eye, ear, and may say extremities, but that's the entire body. If you split it down the middle, you only have 2 eyes, 2 ears, right and left sides, as far as I can imagine.
Well, here, I'll jump in for a particular case I have, which is a truly bizarre case, especially to walk into a chiropractic office. But I have a guy who took a tremendous injury to a testicle and it's going to have to be removed. So there's a body part, but I doubt I'm going to have anything on the opposite testicle as far as that one. So there would be an extremity, a testicle as a region. He's going to have it amputated. It's going to be a significant disability for him. And the real question with that particular case is there opposite and corresponding? Okay, so that would be a good one to raise as an issue.
And there are specific body parts enumerated, such as it says hand, arm, foot, leg, or eye, but obviously ankle, wrist, pinky finger, it is opposite and corresponding, as Dr. Newman said, upper extremity, lower extremity, eye, ear. And I would expect that if someone had an injury to one lung, if you could prove there was a pre-existing, and I want to make sure the way I understood this is that when you're using 5% opposite and corresponding, the pre-existing body part must be able to be rated as a permanent disability. The subsequent industrial injury only needs to affect that opposite side.
That's exactly correct.
Yeah. There was another question, Dan?
Yeah, there's a couple more. We're talking about the 70% threshold. Is that the final PD level, or does that have to be prior to age and occupation?
It's the final permanent disability level. And I'm not sure if we'll get to that issue today. There is a binding and bank decision that says your pre-existing disability and your subsequent industrial are added. So if you have a previous pre-existing disability of a 35 and your industrial case dipped at 50, you would have an 85 for SIF purposes based on the Todd decision. Then the next question is, do you go higher with vocational evidence to prove the person's 100% if they're on SSDI or cannot return to the open labor market?
Okay. Another question we have is the reasonableness of time, or the reasonable time to file an SIF case. Is there a statute that makes these cases expired?
Well, I think we were going to discuss that in the latter part of the presentation. Someone's jumping ahead, but Brett, you want to go, or one of the doctors?
Well, the statute says you have to file within a reasonable period of time. And who knows what reasonable is? The OD Legal, Office of the Director, Legal Department, which is the attorney's office that defends these cases, they will tell you that that's 5 years from the date of injury, 1 year from the date you settled the subsequent industrial injury. There's no case that holds that. There's no statute that holds that. It's reasonable. So that's open to interpretation.
Gotcha. Okay, so next I want to go to Dr. Skala, and my question is, why are we doing this? Why is it really important for us to educate the system, the practitioners on this topic?
Well, I think my contribution today is something of a cautionary tale. There are more and more QMEs getting involved in doing SIF cases. If you look at the demographics of the number of cases that are going into the fund, there's an incredible spike. If it were a stock market surge, we'd all be getting ready to sell and become gazillionaires. Unfortunately, the economics of that put a great deal of strain on the fund. And that means that attorneys and QMEs have to be careful to make sure that they're not putting out, in my case, report product that is just kind of meeting this, well, everybody's got some, so let's just throw the report out there and see what happens. I get concerned when I talk to some of my peers who say they've never seen a SIF case that didn't meet all of the threshold issues. And I can say that I've seen some that don't. So I think from giving, if you will, recommendations to attorneys, how they screen their files to determine which to move forward on and which not to move forward on is important. I know that the vast majority of cases fall in an age demographic of people late 50s to 70 plus. I've seen many of those kinds of cases, and they have many of them rather intricate past histories. And I've seen one of a 30-year-old who had a congenital club foot. And so they're all over the spectrum. But from my point of view, I don't want to author a report that really, when you look at it carefully, there's no there. It's not going to work for the attorney. It's not going to work for the injured worker. And so I'm cautious about too high expectations. And so that being said, I'm more than happy to review a case and give feedback to an applicant attorney to let them know, I think this is what can be done here, but I can't make any guarantees until I start the process. And don't be surprised if after we're all done, it doesn't meet the thresholds. So what do you think about that, Mike?
Oh, I like to work as a team effort with the lawyers in my community that want to learn how to do this. And what I tend to do on Saturdays, because I'm as crazy as Brett and work all the time, I like to have them bring cases down to my office, and we grab about 3 cases. We go through the cases and we vet the cases. And after we've done that 3 or 4 times, they figure out how to do it. You need to know what to look for and things that you wouldn't even suspect would make the cases. Most cases you have, it's an older person who's going to have problems with diabetes, problems with hypertension. Any female who had a hysterectomy, those are really wonderful cases because those are substantial rating cases. Internal medicine problems work very well for it. So a percentage of the people you've seen are good SIF cases. It's a matter of clearly understanding threshold issues and not locking yourself in on that 35% threshold, because sometimes you're not there, but you make it so often on the opposite and corresponding. So look and see what the history shows. And then the other thing that Brett's brought up with the number of cases, these are maybe the worst injured people in the whole system. Most of these people don't have much anything. This is a life-changing event for them. People, they get their settlement from the case and that's some money and they're better, but they're not really good. SIF cases can change lives. It gives you a really nice, warm feeling knowing that you've seriously helped somebody get a better life. We got to do it like Rick said, don't bankrupt the system. You get all these yahoos coming in here with ramming up the fees and trying to kill this golden goose. They're going to kill this golden goose. So don't kill the golden goose. Get good cases. You got enough to do. It takes a while to get through these cases to get them to go. And as you start learning how to do this and learning how to settle the cases and making your client's life better, it's a win situation. But remember, there's a lot of permissibly self-insureds out there that contribute substantial. And as this fund gets bigger and bigger, they're going to get tapped harder and harder. and they're going to be able to do what they're highly successful at doing. They're going to eliminate the SIF fund, and then everybody gets hurt. So it's important, as he said, get good evaluators who do a good job. Make sure the people you work with do a good job, and educate your doctors, and realize this: your chosen evaluator for the SIF case is not bound by the opinions of the AME or QME. AME cases sometimes will create a situation where you have to do a more elaborate discussion of some difference of opinion, but the evaluator, your QME evaluator, can say anything they want as long as their argument is really well reasoned and the judge finds it persuasive. So work with people who know what they're doing, who write a really good report, who don't just throw out a one sentence on apportionment or labor disablement, but really explain it in detail so the judge can read it and say, that's a good report, we can settle on that report. Then we get a win situation. Lawyers are happy, clients are happy, your treating doctors are happy, and we let the golden goose live a lot longer, which is going to be very important and can go away if too many people jump into this thing.
Amen. I would add to that that differently than a straight up QME or AME, when we start looking at all these chronic conditions, particularly talking about the spine chapter, the lower extremity and the upper extremity chapters, the AMA guides suddenly become very generous, because we're seeing people oftentimes in the later stages of these degenerative conditions regarding joints and the and what happens, so long as we can explain a how and why as the evaluator, we find that there's plenty of missed opportunities to utilize exactly the way the AMA guides tell us to do it. I like what Mike does when he says he makes sure that he gets weight-bearing knee x-rays on all of these cases, because if you get to a certain age, and if you do the evidence-based medicine, you're going to find what the statistics are as to how many people over the age of 60 and 70 and what have you already have some degree of loss of joint space in the knee. They don't have to have a symptom in order for that to be rateable. It's because it's a loss of function. And if we're not looking at it, then we're just not doing the best job we can as the SIF case QME.
Let me jump in here if I may, and I'm going to take the webinar and steer it off course. Sorry about that, Dan. But a number of topics here that I think we need to coalesce around. I spoke with 4 QMEs this week or last week about this, and I asked them what percentage of the subsequent injuries fund cases that you are sent do not qualify. And the answer generally was right around 10%. That means that the attorneys are not vetting their cases properly. You're giving false expectations to your clients, but I'm also concerned that the doctors are going to have to spend time on those cases, maybe 10 hours per case. That's a lot of time spent that they're not working on cases that maybe do qualify. So in vetting your cases, I have sort of a rule of thumb. It's pretty loose, but I call it the 40-40 rule. If you've got a case that rates out to 40% and your client is 40 years old, there's a pretty good chance that they're going to qualify for SIF. It's not ironclad rule, but I think it's a nice rule of thumb just to keep in the back of your head. How do you know if they're going to have those pre-existing disabilities? Well, take a look at your AME, QME reports. Look at what medications they're taking. Look at the medical history that the doctor gives you. A lot of times that's not very extensive because they're not looking at the diabetes. They're not looking at the foot injury when you're talking about a neck injury. But a lot of times there's stuff in there that you can go, well, gee, you know, when you start adding that stuff together, we just might be there. Dr. Newman talked about how these things are funded. Where does all this money come from? There, on every workers' compensation policy written in the state of California, there are 2 surcharges. If you look at your bill, you'll see them. One we're familiar with, which is CIGA, the California Insurance Guarantee Association, which steps in and reinsures insurance companies that have gone bankrupt or gone out of business. But there's another small surcharge for the SIBTF, and it's small. You probably don't notice it. The insurance companies don't mind it because Hartford, Travelers, State Fund, they just pass it through to their policyholders, and they don't much care about it. But the big employers that self-insure, they're the ones who drive a lot of this system, and they're starting to care a whole lot. Dr. Newman talked about killing the golden goose. Some of you may be old enough that you remember when we had unlimited vocational rehabilitation expenses. I had one once that went to $250,000. Believe me, a self-insured perks up and looks at that. We used to have unlimited temporary disability, and I had somebody who was on TD for 40 years. Believe me, the insurance company perks up and looks at that. The doctors here are both chiropractors. We used to have unlimited chiropractic. There were some people that abused it, and it wound up being cut to 24, lifetime. Same with physical therapy. So, and penalties. Penalties used to be huge. It was 10%, but it was the entire species of benefit. So if an insurance company was late on a mileage reimbursement, you got 10% of all mileage, and that was huge. Well, we played those a little too well, and eventually we killed the golden goose on those. And it looks like we're headed toward killing the golden goose here. We're bringing some cases, 10%, that should never be brought. I see some large medical groups where the bills never come in less than $6,000 for an evaluation, and I've seen them go as high as $12,000. I got one in just this week, a psych report. It was 212 pages. They're making out just great now, but a few years from now, I think the self-insureds are going to go to the legislature and say, we don't need the subsequent injuries fund anymore. So I want my cautionary note is to be careful, vet these cases, make sure you've got a good case, and make sure you're not just wasting discovery money on things that we really don't need. The pitch that I'm going to make to people today, for those of you that are not doing SIF, you've heard us talk about it, you've heard Art Johnson talk about it. The San Diego chapter of CAW is doing a program on SIF on Friday. In fact, Eric, who's speaking at that, is here on this webinar. Let me suggest, rather than learning on the job, and I know I sometimes think back 40 years to the first 100 cases that I ever handled, probably committed malpractice on 60 of them. God, do I wish I could get those cases back, but you can't. And I don't want people to commit malpractice on these cases. People come to you as applicants attorneys with their workers' comp claim. If you screw up TD or PD or something like that, you've committed malpractice and you could be in trouble. If you don't do the SIF, they didn't come to you for that, you're not obligated to do it. It's not malpractice. Maybe you don't want to do that. And I'm going to suggest, if you think you've got a case, there are people in every community in this state, from San Diego to Orange County to LA to Santa Barbara to Bakersfield, San Jose, Sacramento, right on up the line. There are people who are good at this and will pay a very handsome referral fee. I'm going to suggest, if you vet these cases, you think you've got something, send it over to one of these attorneys in your community to have them look at it, see if they'll do it. Later on, they can explain how they went through the process, and you can learn based on other people's experience. That's the job of us graybeards, is to teach the young'uns how to do this stuff, and you can utilize that. I suspect 90% of the people on this webinar are members of the California Applicants Attorneys Association. You've got access to the listserv LawNet. You can go on and say, gee, I'm in whatever community, who in our community does these things? You can go to your chapter meetings and ask the same question. You can call your chapter president and ask that same question. There are folks that will do this in every community, save you a lot of work. At 2-3 years down the road, you get a check for $5, $10, $15, $20,000 as a referral fee. That's a sweet deal. So I'm going to make that pitch to all of you. I'm not trying to get the business for me, but there are people in every community that do this that you can refer to.
And that's a good segue, Dr. Skala. Do you have any best tips when an attorney is handing you a file? You know, what do you recommend? How do you tell them to help you out on your part of the case?
Number one, records. Different attorneys have different methods of intake. The QMEs have different methods of intake. Review the intake. Look at those health histories. Find out what they've described. Talk to the client. Find out, whoa, you had this cardiovascular event whenever it was. Where did you go for that? And start getting records. You know,
music. That's music to Gemini's ears.
Yeah,
that was not paid for. Just FYI.
Mike and I may get a grimace when the 4,000, 5,000, 6,000 page box of records shows up. But if somebody's gone to the effort of doing their job and getting those records, I'm going to review them, and I'm going to review them with a fine-tooth comb. I know Mike is as well, and most of the other docs who do SIF cases. And if it's a prior labor disabling problem, we're going to look and see how it affected them and create a how and why argument. We can't do that without the applicant attorney doing a good job on the front end of gathering up those records. All of the medical legal records. I just did a case that had 35 prior medical legal reports, and it was a 5-inch thick stack of just medical legal reports. Oh, there were so many gems in there. Oh, it was, you know, some of them contradicted one another so far as past medical history, just to the extent that the evaluating doctor did or did not get a comprehensive history. But it seems psychologists seem to get the most comprehensive prior medical histories in my observation. But again, so that's my addition to all of that.
I have an addition to throw at everybody here too, and that is learn to use your resources. One great resource is a defense attorney on your SIF case, because they will have really gone to the ends of the earth to get past medical records. And I've recommended to my applicant attorneys subpoena the defense attorney for their records. It's a nice, easy place to go. And they will have done a really good job to find stuff to deal with apportionment. So use that as a tool to help get yourself the additional records that need to come in.
Yeah.
Well, since you're talking about records, let me ask this question, doctors. If you had your druthers, would you rather get paper records or would you rather get them on a disc?
Disc for sure for me.
I'm halfway on one side and halfway on the other side. When I get a disc that isn't in order, I hate to review records that aren't in chronological order, and normally we print them up and we go through them and we put them into chronological order before we even start to review them. And I know a lot of guys will just review them as they show up in the pile, but my preference is review records in chronological order from oldest to most recent. And so typically we're going to convert the CD to paper in our office. And, you know, I'm willing to absorb the expense of a few reams of paper here and there.
I use twin screens. For me, the CD works great. I have the records on one side, I do the report on the other side, and I move through it as I do it, and I jump around the CD as I need to, and I find it very convenient to work with the CD, much easier than thumbing through paper all the time.
Well, then let me throw a question into Dan. If Dr. Skala were to call Gemini and say, I've got this disc at 6,000 pages, I want paper, will Gemini then convert that to paper and send it over?
We will not get paid for that, but yes, we will. Mr. Thomas, do you have anything to add? You know, best practices, tips for our audience here?
Yes, it's going to kind of go back to what Dr. Newman said about the vetting process. And I think all the panelists have mentioned it. Without admitting to any potential malpractice. I look for clients that got, pardon my French, screwed by the system. And when you have a client who was making 45, 50 grand a year, who's in their late 40s, early 50s, and they lose that job because of a 35% post-industrial injury rating, or let's be generous, a 40% rating. This guy, male or female, lost an opportunity to put another 8, 10, 12 years in their Social Security account, lost income to pay for family needs. That person was harmed by the system, not helped. So those are the cases that I look at and I just go, there's something here. If your client goes back to work for the same employer or is another employer making more and same amount of money, they may have, if it was a amputated foot. I had a gentleman who was born with just dots for his fingers, lawnmower, Parks and Rec guy for the city of Huntington Beach, great SIF case. So that's what I look for first. Why is my client not financially repaid, brought even, made whole by the system? And I had a high-level security officer for a city agency, was not a sworn officer, hypertension, some bad internal, and because he wasn't covered by any of the presumptions, the doctor gave 40 and 60% apportionment to kidney failure and heart problems. Turns out he had been blind in an eye, from one eye from birth. Did not know this. He carried a weapon. He was able to pass the marksmanship part for his job with one eye. So after we CNR and he's in my office and I'm just moaning that I think we got you-know-what by the system. Oh yeah, I've been blind. I never tell anybody because I don't want to get fired from my job as a high-level security officer. We are not, he's found part-time work, so I'm probably going to be able to get him in the 80 or 90% range on what was originally a 60% PD, cash value of 300 grand versus 70 or 80 what we got in the CNR. That's what we're looking for when someone has been just messed over by this system because of apportionment or the roll of the dice on the doctor.
I knew I liked you guys for a reason.
Well, all right, let me tell one of my favorite stories, and that is Park. And Park was a property manager managing a large apartment building and developed bilateral carpal tunnel. We eventually settled Park's case for somewhere around $50,000, $60,000. I don't remember, a nice number. But maybe that enabled her to get out of debt. I'm not sure. Eventually, she couldn't afford to live in California anymore. She moved out of state. I filed a subsequent injuries fund case on her behalf. We did the workup. Through the whole thing, Park is saying, Brett, I really need a new computer. Am I going to get enough out of this to buy a computer? And I try to dampen down expectations. So I said, yeah, I think we can get enough to get a computer out of this thing. We eventually stipulated the SIBTF case to 100%. Park received a retroactive check to bring her up to the TD rate for life of net of $250,000. Huge. How many of you have ever gotten a check made out to you for $250,000? Not many of us, not very often. So I'm talking to her. I said, well, what are you going to do with that money? She goes, Brett, I have no clue. I've never seen this kind of money before in my life. I said, all right, go down to the local Charles Schwab office, open an account, put 60% into a total stock market index, 40% into a total bond market index. Just leave it alone. Don't ever touch it. Take the interest off of that and live on it. I talked to her about 6 months later and I said, so what happened with the money? She said, oh, you're not going to be happy with me. And I went, oh God, God knows, it's probably all gone by now. She said, no, what I did was I bought a house. Now, this was out of state. I said, what'd you put down on the house? She said, $75,000. I said, all right, buying a house is a good thing. What'd you do with the rest of the money? She says, that I took to Schwab and did what you told me. I said, all right, well, you know, $75,000 on a house, that's a good deal. What's your mortgage payment? Because that's, you got to be able to do that. She said $1,800 a month. I said, well, how are you going to do that? How much do you get from the subsequent injuries fund? You get paid every 2 weeks. So let's call it the first of the month. What do you get? She said, $1,800. I said, well, that pays your mortgage right there. She goes, that's right. She said, I said, and then you get another check on the 15th. She said, you got it. She said, Brett, I am 65 years old. And for the first time in my life, I'm a homeowner. The pride in her voice, that you just know you have changed this person's life for the better. And it's a great feeling. You can't really do that under workers' comp.
Wow, that's a great period to the end of our presentation here, Brett. We all know that injured workers need as much help as we can give them, as much support as we can give them. The SIF benefit is theirs if we do our jobs. So I want to thank our panelists. My name is Dan Borah. I am founder and CEO of Gemini Legal. All of your questions, we did get a lot of questions. We will record those and we will send those back out to our attendees. Thank you again for everyone attending. We had a really good showing, an amazing panel. Thank you, Mr. Borah. Thank you, Mr. Thomas. Thank you, Dr. Skala, Dr. Newman. Thank you so much, and everyone have a wonderful day.
Thanks.
Thank you. Take care.